Hello, everyone, and thank you for joining us today. I'm Jason Kellum, 2024 Chair to the NC Realtors Appraisal Committee. We're excited to be hosting today's webinar. But before we get started, I want to cover a few housekeeping items. First, there will be a Q&A session later in the hour. You may submit live questions via the Q&A tab, and Craig will do his best to address as many as possible as time allows. We will be recording today's webinar and will email each of you a link to the recording. Now, I am honored to welcome our speaker. Craig Capilla is a trial lawyer with Franklin, Greenswag, Shannon, and Capilla, LLC, concentrating his practice in a wide range of civil litigation, including professional liability and commercial claims. He has successfully defended residential and commercial appraisers, appraisal firms, and the appraisal management companies accused of negligence or improper activity in their valuation services. Today's session will explore recent developments in bias and discrimination claims impacting residential and commercial appraisers, including legal trends, enforcement investigations, and strategies to mitigate risk and valuation practice. So Craig, thank you so much for joining us today. I'm going to go ahead and turn it over to you.
Great, and thank you very much for having me today. Great to be here. Appreciate the opportunity. Thank you to all of the attendees who are getting settled in here. As mentioned at the outset, we will do some Q&A, so there is a question and answer dialogue box. Please go ahead and get your questions in there, and I will go ahead and get to as many of them as I can. As mentioned, I have a bit of experience in handling some of these cases. I'm based in Chicago, Illinois. I'm licensed to practice in Wisconsin, Illinois, some federal districts. My valuation practice, though, has really taken on sort of a national overlay at this point. There's not a whole lot of us doing this. I will say you all are blessed to have, honestly, one of the best in the business in your own backyard, Mel Black. So for any of you that know Mel, you know what I speak of there. For any of you that don't know Mel, frankly, you should. You could not ask for a better resource, and it is a homegrown resource to you all. Similar to Mel, we come at this from a couple different perspectives. We've been in government, we've been out of government. I am a former licensing prosecutor for the state of Illinois. I did that for 4.5 years before I came back out into private practice. My crash course into valuation and appraisals was I was a transactional attorney. I was doing residential, small commercial transactions, and that market was really drying up. You can already pretty much tell we're talking 2007, 2008. And so I needed to go find another place to hang my hat. I went into government as a licensing prosecutor for the real estate division here in Illinois, and I started the Thursday before Bear Stearns collapsed. So couldn't have timed it any better, and the next 4.5 years was sorting through a lot of mortgage fraud and the like. The phenomenon that we're going to talk about today, which is the focus on bias and discrimination in valuation, is something that I don't think I've seen at a volume since those days of 2008 through 2012, 2013, really, in all of the foreclosures and all of the repurchase demands of that time. We're not seeing the same claims level that we saw back then. We're not seeing the same dollar figures or anything along those lines, but this really is the first coast-to-coast phenomenon where we're talking hundreds of cases that have come up, and this has been true now for the past 3 or 4 years. So what we're going to discuss today, we're going to discuss a couple of the federal lawsuits that have been out there. We're going to discuss the regulatory process with these. We're going to discuss the role of the GSCs in this process and how they're addressing it. Then we'll talk a little bit about where we're at, where we think we're going from here. And then, as I mentioned, there'll be time for questions and answers as well. So again, and I'll keep prompting you for this, please do, if you have questions as we go along, get them into the question dialogue box. They'll get posted for me, and then I will be able to get to those questions as we get towards the end of this hour. So first and foremost, let's start off with sort of the shot heard around the world. This is the case that anytime you talk to anybody who has even a limited knowledge of bias and discrimination in appraisals, this is the one that comes up. It's the first one that hit national press. It's the first one that got widely discussed and, in fact, ultimately became the subject of a documentary on ABC and Hulu and all of that. The first matter that came up in all of this was in California, in the Bay Area, Northern District of California, in their federal court system. This is the Tate Austin v. Miller matter. So Tanisha Tate Austin and Paul Austin were homeowners in the Bay Area. They filed a lawsuit along with Fair Housing Advocates of Northern California. They filed a lawsuit against Jeanette Miller, the appraiser, Miller and Parati Real Estate Appraisals, which was the firm, and then AMC Links, which was, of course, the appraisal management company. Earlier on in the process of this case, the appraisal management company settled out. And so it left the appraiser and that appraisal firm sort of to go it alone and litigate this. Ultimately, this case did resolve in a confidential settlement as well, or I should say confidential, at least in as far as monetary terms goes. What we do know is that there were certain requirements of the appraiser to settle this case, up through and including the appraiser was actually required to watch the ABC Hulu documentary on this case. So in essence, the Jeanette Miller got a chance to sit there and see herself on screen being accused of all of these terrible things. The part that we don't know in all of this is what the actual dollars and cents were from either the appraisal management company or the appraisal firm and Jeanette individually, all as a part of their sort of insurance packages. But the reason we still go back to this case and discuss it now, as it's been, it's been settled out and closed for a while, the reason we go back and to discuss this case is this was the first moment where the approach to considering these bias and discrimination claims was really unveiled. And I like to remind people to think of it in this frame of mind, which is don't think of this as a complaint, as a lawsuit against the appraiser. This is actually the beginning stages of the sales comparison approach in valuation being put on trial. The reason I say that is the attorneys for the plaintiff in this did a very good job of articulating their position and letting you know exactly what it was they were trying to root out, which is historical inequity in valuations. So that takes us into the facts section of the complaint, and you'll all get a copy of these slides, so you'll have this. I wonder how many of you, and when I do talk about this case, I ask the people in the room, how many of you in your offices had or still have a copy of the textbook written by Frederick Babcock? Okay, so this complaint lays out here that throughout the 1970s, textbooks used to educate and train appraisers contained explicit instructions that housing appraisals must start with the appraisal of the neighborhood. In fact, we're still asked to describe the neighborhood to our readers, to our clients. And racially segregated white neighborhoods were desirable, as opposed to houses located in predominantly white areas were assumed to be of highest value. Predominantly non-white areas were assumed to be undesirable and of lower value. Now, here's the key phrase that comes from that Babcock book in 1924. The habits, the character, the race of the people are the ultimate factors of real estate value. That's right there. It's right there in the foundational text of appraising. The race of the people listed as one of the ultimate factors of real estate value. And then it tells you right here, Babcock went on to become a founding member of the American Institute of Real Estate Appraisers, which, as you know, when it blended together with the society, we're talking about the predecessor organization of the Appraisal Institute, and the head of underwriting for FHA. In fact, it's worth noting here, Mr. Babcock was actually instrumental in creating redlining as performed by HUD. So think of this, nearly a century later, HUD now is coming back out to come after appraisers to clean up the mess that HUD created for itself by being with Federal Housing Administration, prompting redlining. Okay, this is sort of HUD coming out to clean up the messes that it's created, but this is what we're looking at here. So further on in this complaint, so that tells you the baseline of where this conversation started. Further on in this complaint, it goes into the specific areas in question in this appraisal report. So for those of you that don't know the Bay Area, what I will tell you is that the subject property is located here, talks about being in Marin City. It is on the north end of San Francisco Bay. Marin City is an unincorporated community within Marin County on the north side of the bay, immediately surrounded by or adjacent to Sausalito and Mill Valley, which you will see referred to here in this instance as where plaintiffs would have preferred sales comps to have been selected. Folks, I live in the city of Chicago. I'm fortunate to have a lovely house on a double lot here with my wife and kids, and my dog can run around in the yard and play. It's all great, okay? I, too, would like to have comps from Mill Valley, California used when we're looking at putting a value on my house here. Median value as of the time this was going on, the median value in Mill Valley was $1.7 million. We would all hope that Mill Valley comps get used for us, okay? But understand again, this is part of that process wherein the plaintiffs are laying out a claim that sales from outside of Marin City, from outside of the subject's immediate community, should have been utilized to achieve, bluntly, a higher valuation than what was initially given by Miller in this case. That then goes and gets articulated a little bit better in the next case that we're going to talk about. In fly across the country now, much closer to you all, now we're talking about Baltimore. And so many of you may be familiar with this case as well. Nathan Connolly and Shawnee Mott are the plaintiffs in that case, having filed a complaint against Shane Lanham 2020 Valuations, which is Shane's company, and LoanDepot.com, again, the appraisal management company in all of this. Loan Depot, as always, is out of this as well. So the complaint goes forward against Lanham in 2020. Couple of things moved around in the ether on this one. Miss Mott has actually passed away during this process, so it's just Mr. Connolly proceeding on this. Mr. Connolly and Ms. Mott were both professors at Johns Hopkins University. They are living in a house in the city of Baltimore. Lanham comes, appraises the property. Lanham has actually countersued them in this case with a defamation claim. His countersuit is essentially that when Connolly and Mott went out after the filing of this lawsuit and went out and spoke to the press and made statements that they knew those statements to be false at the time, and yet they made them anyway. And so he has filed a countersuit for defamation against them. This carries forward to this day with Mr. Connolly and Mr. Lanham still facing off with competing claims here. But the crux of the bias and discrimination claim is, in essence, the same as it was in the California case we just talked about. It's just articulated a little bit differently here, and I think it more refines the point that it's actually the sales comparison approach itself that is being called into question here. So talking about this here, again, in the facts section of the lawsuit, to appraise plaintiff's home, defendant Lanham used the sales comparison approach. In this common appraisal method, an appraiser assesses the value of a home by identifying recent sales of similar homes in the area, called comparables or comps. The rationale underlying this approach is that sales prices of comparable properties from the same neighborhood from a similar time period are considered the best indicator of value. However, it simultaneously presents significant fair lending risks, as appraisers have broad discretion in selecting comps and establishing neighborhood boundaries. It may surprise some of you tremendously to find out that you have broad discretion in selecting your comps and establishing neighborhood boundaries. In fact, I think a few of you are probably ripping your hair out right now saying, I have no discretion whatsoever over neighborhood boundaries. That's basically dictated to me by the market data. I have no real discretion in selecting comps. The market data tells me what the comparable sales are. That's all well and fine. And frankly, that's how you've been taught. That's how the vast majority of you approach what you do. Understand that these complaints, two things are happening here. One, they're being drafted by lawyers to paint this in the light that is most detrimental to the appraiser. But two, don't forget that there's only about 75,000 of you nationwide in a nation of 380 million people. The vast majority of the public has absolutely no idea what you do or how you do it. And that's what allows these misconceptions to then get smoothed up, polished up, and turned into particularly damaging statements. Okay. So again, it may be shocking to you to find out that you have broad discretion in determining what these neighborhoods are and selecting your comps, but that's what the public is being told that you have and that you do. All right, so going further into this, now they get really into the meat on the bone of this particular appraisal. Says Lanham blatantly violated professional appraisal standards by improperly limiting the geographical area from which he considered properties to compare the church warden's home. Church wardens is the subject neighborhood within Baltimore that we're talking about. He did not pull comps from throughout Homeland, but instead limited his search to houses north of Northern Parkway. All right, I know none of you are on camera right now, but let me just take an unscientific show of hands. How many of you have ever limited your searches for available comparable sales to one side or another of a major thoroughfare or roadway? Look, I can't even see you, and yet I know that every single one of you has your hand in the air right now. Of course, that's a factor in this. Whether it's a highway, whether it's another major roadway, or some other line of demarcation, it's all about how you filter your data and move on. Yet again, as styled in this complaint, it's suggesting that it was absolutely improper for the appraiser to do so in this case. And further, defendant Lanham thereby limited his search to about 16% of the total land area of Homeland. This excluded over 80 potential comps of the almost 100 available, leaving him to choose from only 15. Some of you out there right now are doing cartwheels over the idea that you might have 15 available sales to analyze in a particular assignment. That's the salad days when we get one of those assignments, right? We don't always even get 15. The fact that he had all of this material to choose from and said, actually, I'm going to slide this down to these are the best, most appropriate 15 from directly in my area that I can deal with, that actually sounds like a pretty good day. Ultimately, Lanham chose and considered 3 comps that were north of Northern Parkway, and one of those comps was located outside of Homeland proper in a majority Black census block. Okay, so now they've actually articulated that one of the sales utilized was out of the subject neighborhood area. Was that appropriate? Was that inappropriate? Well, it's being asserted here that it was inappropriate to do so. I would think further analysis and probably further explanation on the part of the appraiser is necessary here, but it may be entirely appropriate. There could be a reason that even though it's outside of the immediate subject neighborhood and subject market area, it might be appropriate to all of this, or rather, it's within the market area, it's within the market segment, though not specifically within the defined neighborhood. That may be perfectly appropriate. Again, just based on what we're being given here, we have absolutely no way of knowing that. But again, you see how this whole process is keying in on taking aspects of the development of the sales comparison approach and questioning whether or not those parts of the process are appropriate or whether they are inherently discriminatory. These cases as a whole are taking the idea of the sales comparison approach and really challenging that, particularly the geographic reliance within the sales comparison approach. They're really calling that into question. And depending upon if we ever got any of these cases to being fully adjudicated, we would all be finding out together as to whether or not the fundamental processes of the sales comparison approach are going to hold up, or whether they're going to get thrown out with the bathwater. We may get to some sort of an adjudication here in Lanham. We don't know that yet. What I will tell you, though, something else comes out of this case, and it actually comes out of the settlement that the appraisal management company went through. So here's some additional terms from this case, but in the Loan Depot settlement, okay? A couple of things are notable in the settlement with the AMC. And you'll see one section here talks about reconsideration of value practices and policies. Loan Depot shall communicate clearly to applicants that they have the right to request an ROV. Loan Depot shall in clear and plain language inform applicants about how to request an ROV, the process by which Loan Depot handles ROV requests, who will review an ROV request, and the standards that trigger a second appraisal. All right, folks, if this sounds familiar to you now, it's because as of October 31st, the new policies and procedures for borrower-initiated reconsiderations of value took effect. From FHFA on down to all its participating lenders and basically anybody else in the lending chain and who's a covered party under Dodd-Frank. This part of the settlement agreement is the language that gave rise to the FHFA work group that worked out and resolved ROV policy concerns. It was also a part of the PAVE report, which is the task force that was put together at the behest of the president to analyze what was going on here, and consulted with attorneys and consumer advocacy groups and the GSEs and the like. And what came out of this was ultimately the policies that are now effective as of October 31st of 2024. Prior to that, and for anything other than a borrower-initiated reconsideration of value request, there are no policies and procedures for an ROV. An ROV is not new. ROVs have been around pretty much since FIREA, but there's never been one set of rules for everybody to understand and play by. But specifically for borrowers, there is now. And the intent of that is to try to prevent claims like this from occurring. It's to provide for the borrower an avenue to raise questions and concerns before a lending decision is made and any harm can occur. Part of that involves selection of up to 5 additional sales to consider. One time, one shot at all of that, addressing defects, potential defects in the appraisal report. And if those concerns can't be cleared, then to have a triggering event to order a second appraisal. The part that I need everybody to be crystal clear on, because it's not yet, and people don't understand this, is that if there is a request for a second appraisal, it becomes a triggering event by which the first appraisal must get turned in to the state license board in whichever state it occurred. I work with real estate brokers and agents too. I do a lot with NAR, local area associations, commercial overlay boards, and frankly work with a lot of brokerages here and there on compliance concerns. I have on multiple occasions had real estate agents, real estate brokers talk to me about, oh yeah, no, absolutely. I mean, as soon as I get an appraisal back for my client, I immediately go ahead and put in a request for the second appraisal because it always comes up to a better answer. I said, okay, do you understand that that requires that a license complaint gets filed against the first appraiser? You'd be shocked, or you wouldn't be shocked, to find out how few people actually know that and are aware that that has a triggering requirement for the filing of a complaint. But that is an enumerated part of this process. And that's been true even before October 31, when that kicked in. The request for a second appraisal is a triggering event under Dodd-Frank, under TILA, that it actually requires the lender or the appraisal management company to make a report to the state licensing board against the appraiser. Okay, on top of that, This settlement agreement also has that Loan Depot shall maintain timelines and protocols for communicating the status of ROV requests, and that ultimately internal, independent of an ROV, there shall be policies for an internal review for any indicia, it says, of discrimination and flag appraisals if such indicia are present. That's important here as well, because again, that requires one, that if the lender just internally reviewing things, or the AMC internally reviewing things, they think they've identified something that appears to be discriminatory, they are to order a second appraisal and turn in the first appraisal. There is a pending case right now in Tennessee that we're watching. It is not a bias or discrimination claim, so I didn't include it in this deck, but it's one that at least the lawyers we're all watching right now, because it's the first time we've seen any real enforcement of the mandatory reporting. An appraiser went out and valued a property. Lo and behold, that loan didn't close. They turned around, went ahead, and another participant came in. Within the month, they get the same assignment over again. Happiest day of that appraiser's life. Like, just did that one. I'm good to go. We can do this. What they didn't realize is in the intervening several weeks, there had actually been a lot of material changes to the condition of the property. Nevertheless, they basically went ahead, regurgitated the initial report, addressed it to the new client, sent it off, and off it goes. On the basis of that, the loan app was actually rejected because the collateral didn't come through on this one. The collateral valuation didn't come through. Nevertheless, the borrower, or the prospective borrower, files a lawsuit against the credit union and the appraiser, goes after the appraiser for negligence and breach of contract and all this other stuff. The appraiser mostly skates on that because the borrower doesn't really have an avenue back to the appraiser. Now, interestingly, most of the complaints about the credit union fail as well, because in fact, they didn't lend, they didn't rely, no decisions were made on the value opinion. They didn't do anything because there was no loan made. But where their feet are being held to the fire in this instance is there was one throwaway claim that the borrower made and that the court has allowed to stand, which is under Dodd-Frank, under TILA, the credit union had an obligation to turn the appraiser into the state board and didn't. And so the lawsuit persists as to whether or not there's actually damages available to the borrower because the credit union didn't turn the appraiser in and report them. So we're all fascinated to watch this one because that hasn't happened before. But it's in furtherance of what we've talked about here in the Loan Depot settlement, which is this talks about mandatory reporting. And for once, people are really looking at it and going, holy smokes, is there that obligation here? Peter, I see you have a question in, and I am actually going to jump on that one now because it's specific to Loan Depot in this case. For those of you who can't see, and I'm not sure that you all can, Peter Gallo just popped up with Loan Depot settled after having claimed that they were not responsible for the appraiser's behavior. Now we see Rocket Mortgage making the same claim in their dismissal request in their case, which is, for those of you that don't know, there is an active pending HUD discrimination claim in state of Colorado involving Rocket Mortgage, Solidify, and an appraiser. So the question was, now we see Rocket Mortgage making the same claim in their dismissal and the request in the case. What's your view on this? OCC has said that banks are responsible for their third-party agents. Would non-bank lenders be seen as having the same liability? If a mortgage lender utilizes an AMC, many of which are owned by the mortgage lender, which seems like a violation of something. Peter, I'm with you on that one. And the AMC hires an appraiser based on fee and turn time, not qualifications of the appraiser. How would they not be liable for the actions of the appraiser, even if twice removed? Well, not to steal thunder from my dear friend Mel Black, who's in your state, but I will start answering the question by saying, well, it depends. Okay, now that we've got that one out of the way, what I will tell you is it does depend. The reality of it is the conduct of the AMC, the conduct of the lender, is going to get called into question here, which is going to be, what did they do? What were their processes? Did they have any internal fail-safes? Did they review and check this stuff? And if they did they determine there to be any problem? If they said, well, we've reviewed it vigorously and we found there to be no problem, then they're going ahead and sitting in the seat right next to the appraiser. If they look at this and say, oh, we reviewed this and we thought it was terrible, but we didn't do anything about it, we're sitting right next to the appraiser in that mess. If we're looking at it and going, we thought this was absolutely terrible, so we washed our hands of it, we turned them into the state board, and we don't know what happens from there. Again, it wasn't our fault. We didn't do the appraisal. We found it was a problem. We ordered another appraisal, and we sent the first one into the state board for them to figure out. That lender's probably walking away from this relatively unscathed, because they can say, we took steps in furtherance of protecting the borrower, and we've raised the flag that we think there were problems occurring in all of this. But it gets a giant it depends, because we haven't actually seen that fact pattern play out and get adjudicated yet. What we've got is we've got various participants in these matters who have settled out over time. And will that ultimately be a successful claim for dismissal on the behalf of Rocket Mortgage? Proof is going to be in the pudding. What else did Rocket Mortgage do with that? If it's simply a matter of just raising their hand and saying, hey, we didn't do that, so it's not our fault and you can't blame us, I don't think that's probably going to be good enough to walk away from all of this. If it's, hey, you know what, that guy did it, he's independent of us, we took it, we vetted it, we have serious problems with it, and so we did X, Y, Z, we're maybe having a different conversation there. But we'll have to see how that plays out in real time. One other specific lawsuit that I want to bring to everyone's attention that not everybody's talking about yet is not involving a single individual appraiser at all, but it's significant. So we're back in California, folks. We're back in the San Francisco Bay Area, Northern District of California. Wells Fargo is staring down the barrel of this one. And I'm sure all of you here are horribly concerned about Wells and hoping they all get fair treatment out there. So what we're looking at in this case, and again, I'm pulling clips from the actual complaint lodged in this case. Some of this may make your hair curl a little bit. With respect to refinancing, Wells Fargo denied the applications of over 50% of the Black applicants seeking to refinance in 2020, and denied the applications of just under 50% of the Black applicants seeking to refinance in 2021. No other major lending institution refused to refinance the homes of Black applicants at such stunning rates. Wells Fargo was the only major lender in the US that approved a smaller share of refis from Black homeowners in 2020 than it had in 2010. That year, while Wells approved 71% of the residential refi apps from white Americans, it approved only 47% of the residential refi apps from Black applicants, 53% of the applications submitted by Hispanic or Latino, 67% of the applications submitted by Asian Americans. When compared to other lenders, which had approval rates of 71, 79, and 85%, respectively, for the same racial groups, Wells Fargo's statistics are stark. And yeah, when we are looking at raw numbers like that, I think stark is probably a good adjective to describe what we are looking at on that one. So that right there is just one facet of Wells. But why does this matter to appraisers? We're talking about underwriting. We're talking about loan approval rates. What do you care as the appraiser? Well, I'll tell you why you care. Because further on in the complaint, this talks about uncorrected and racially biased appraisals. Wells Fargo also considers uncorrected historical and current appraisal data from geographically differentiated locations in its refinance evaluation process. Race stratified differentials in appraisal data are well known to Wells Fargo and others in the banking industry. Indeed, according to the March 23, 2022 report in the Washington Post, citing Brookings Institution data, we'll come back to that in a second, quote, homes in Black neighborhoods, end quote, routinely appraise at 23% less on average than those in comparable white neighborhoods, despite having similar neighborhood and property characteristics and amenities. So that's coming from the Brookings report, which got out there early and obviously in advance of March of 22, because that's when Washington Post cited it as, fact determinative. As you know, or as most of you may know, there are other research studies that have been conducted that tend to refute some of the points of Brookings. But the reality of it is Brookings was first to the table with their analysis of what was going on. And what you see there in this complaint is a restatement essentially of what was given by the analysis of Brookings. It goes on to say further that Freddie Mac has similarly found that 12.5% of appraisals for home purchases in Black neighborhoods and 15.4% in Latino neighborhoods came in below the contract price, compared with 7.4% of appraisals in white neighborhoods, end quote. And that's a direct quote from Freddie's analysis on what they're seeing in their own portfolio. The below market appraisals, now this is not a quote. This is the stylings of the attorney bringing this claim, and it's going to be important to unpack this. The below market appraisals intentionally skew the loan to value calculations against Black homeowners and prospective homeowners and serve as a tool for racial discrimination. On its face, and with the quote that was just presented to you there, you can see how that next statement follows. What I'll tell you is that's not really my read of all of this. I'll tell you what my read of this is. The Freddie Mac analysis of their internal data, in my book, does not show that these appraisals came in at below market value for these predominantly minority neighborhoods. No, alternatively, what it suggests is that white or predominantly white neighborhoods, white borrowers, actually tend to get overvaluations at a much higher rate than predominantly minority applicants. So there is a problem here, and it is going to come home to roost at some point. They're basing whether or not it is a market valuation based on whether or not the appraiser came to the contract value. I understand that appraisers are required, when applicable and in the ordinary course of business, they are able to obtain a copy of the contract in a transaction scenario. It doesn't mean the contract is always right. As I told you, I started as a regulatory prosecutor the Thursday after Bear Stearns collapsed. The Thursday before Bear Stearns collapsed. As a result, I can tell you a whole lot of examples of where an appraiser went ahead and agreed with the contract price, regardless of whether or not the available sales data actually supported that opinion. This paragraph is begging for that same impact, which is, give them the amount they're asking for, not just the amount that you think you're seeing in the sales. We're asking to solve the wrong problem here, but as you can see, the way this is styled, it's suggesting that that's evidence that valuations in predominantly minority neighborhoods are purposefully, discriminatorily being held down, when the actual evidence suggests appraisers are missing the target over the top and predominantly white neighborhoods. That's a different problem that's going to come home to roost at some point, and we're all going to be stuck dealing with again. But we're not talking about that problem right now because it's being styled to stand for almost the opposite, okay? Now, all of this leads to the influx then of complaints at HUD. HUD is the federal agency who has been, since the fair housing laws took effect, beginning back even as early as the 1960s, HUD is the agency that is charged with investigating and enforcing these national fair housing violations. And so, as many of you are aware, there are a number of complaints that have been lodged at HUD. We've already talked about one case that's actually going forward. That's in Colorado. A handful of these cases have settled out over time with either a conciliation agreement, or I can raise my hand and tell you that I've settled one off book back in the summer of 21. I have cases currently going in 12 or 13 different states. with these HUD investigations. In fact, I actually received a new one this morning. That's in the state of Washington that we're going to be coming in on. So they're still coming. They're still coming in the door even now. Here's what you would see. This is a real live document from one of my case files. July 28th, 21, appraiser X gets this letter from HUD. Dear respondent, housing discrimination complaint. We've received a formal complaint alleging that you have engaged in one or more discriminatory housing practices under the federal fair housing law. And it gives you the section to look at. We're enclosing a copy of the complaint so you get what was alleged asserted against you. This is the purpose of this letter is to inform you of the rights that you have, the rights that each complainant has, the steps that HUD is going to take in order to ensure the department properly informs you of all the law's requirements. This notification letter contains language required by law. We're governed by federal law, which sets out the steps we have to take when a complaint's filed and the steps that you can take to answer. Under federal law, any answer from you to this complaint can be filed within 10 calendar days of your receipt of this letter. So you get this letter, someone is accusing you of participating in a violation of federal fair housing laws, and you have 10 days to get an answer into them. And that's important because they have 180 days to conclude their investigation of this claim. So you got to get your answer in, get it to them so that they can thoroughly vet that. Now, notice that this case is from July of 2021. I bring it to you because it's still open, as are all of the rest of mine, some of which are rapidly approaching 4 years of age. All of these ideas that HUD was going to be able to work their way through these, process the investigations, and come to a resolution, all of that has been thrown out the window. When you talk to the various field level investigators within HUD, unlike other fair housing claims, whether it's a rental discrimination or a transaction, you're refusing to sell to a purchaser of a particular race, or you're refusing to lease to a purchaser of a particular, they're well attuned at dealing with those kinds of claims. They have a timeline to adhere to. They have a process out of each of the field offices. They go out, they make their investigatory notes. They interview both participants. They package it all together in a summation, and they write whether or not the charge has been substantiated, and they send that off for distribution. Close it out, we didn't find anything, or yep, we found something here. Send it further up the chain and start pushing this towards a resolution. The field level investigators have been handcuffed at HUD, and they are not allowed to make that determination in the valuation claims. All of these have to get sent to the DC office for further review, for the DC office to determine whether or not a claim has been substantiated, or in many cases, to get sent back and to request more information. I have seen requests for several months worth to several years worth of send us a copy of every appraisal report you've performed over the last several years. In fact, in Region 5, which is the Midwest here, this is a spreadsheet that the HUD investigators send out to the respondents. Give us the property address, give us the date of the appraisal. I've tried to get 2 columns removed from the spreadsheet. I managed to get one of them removed. It's property address, date of the appraisal, appraisal value, name of the lender requesting the appraisal, loan number, refinance loan or purchase, type of dwelling, refinance loan amount. That's the column I tried to get removed and failed. And I had to have a conversation with the investigator at HUD. Said, hey, the appraiser doesn't get a copy of the amount of the loan requested. They're supposed to guess it. That's sort of the whole point of the exercise. They were surprised to find that out. They thought, oh, you get a copy of this. It says the borrower is looking for, I'm gonna make up a number here. The borrower is looking for 175. Can you support that? No, that's not the process at all. And you know that. And for those of you that were around in pre-HVCC, pre-Dodd-Frank days, and the bad old days before 2008 happened, that's maybe a different conversation. We actually put that concept out to pasture for a reason, okay? but I still wasn't able to get that column removed out of here. So instead, it's I don't know, I don't know, I don't know, I don't know, I don't know. Then it asks for contract price, and it asks for the name of the AMC if there was one. Alternatively, there was a column that used to appear on this document that isn't there anymore. They were also asking for, in every single appraisal assignment that they were getting a copy of, tell us what the race of the borrower was. Because again, they didn't know any better. They were told this will all be in the appraiser's notes. What's the race of the borrower? It's going to be in there. So have them put this for every assignment they took. What was the race of the borrower in this assignment? And have them fill out this column too. Well, I got that one removed off of this spreadsheet, but they still want to know what the amount of the loan requested was. Okay. So that's the sort of thing that we're looking at the HUD level. Now, I'm going to pause briefly on this idea to try to touch on what comes next at the HUD level. And the short answer is, I don't know. As you're all aware, we have a new administration coming into office here soon. What's going to come of all of the HUD claims? Nobody has any idea yet. I've seen a lot of spouting off and speculation on various internet forums and whatnot. And the reality of it is, nobody knows anything. There is an expectation, though, if HUD does not proceed with pushing these claims forward to some sort of a resolution, the fair housing advocates that are out there are just going to begin filing these as civil lawsuits instead. They'll get tired of waiting for government action and take the route of the Connollys, Motts, and, so you'll see the federal lawsuits potentially come out of this if they're not being addressed at the government level. This remains to be seen. We're going to have to watch this over the next 6 months to 12 months and see where it goes. But in the meantime, that's what we're looking at here. And of course, the GSEs have gotten involved as well. They have been going through all of their appraisal assignments that they've taken in on all the various loans they've picked up, and are going back through and reviewing these for any of the indicia of bias and discrimination. And a goodly bit of that is being done by way of looking for various terms used and what's loosely referred to as subjective language. So what you're seeing here, this comes right from Fannie Mae. In the last 4 years plus, Fannie Mae has been #1 with a bullet, the #1 complainer in every jurisdiction in America. Every state regulator I talk to is always the Fannie complaints are the highest volume of everywhere, and then everyone else falls in line after that. And later, Freddie has started getting involved in that as well, but primarily started with and has been predominantly Fannie Mae. They are reviewing all of their records, and in their selling guide now, they give you, under what's considered unacceptable appraisal practices, they give you a list of things. Many of these things have already been there, but one of the things that comes up now is, because for lack of a better term, because I don't have a particularly good one, we'll call this, we kind of refer to it jokingly internally, as these are sort of George Carlin's appraisal dirty words. Now, some of this stuff might just seem obvious on its face. You might or might not be shocked to know that I still get appraisals that hit my desk from time to time that comment on pride of ownership. I really did think that one had gone the way of the dodo quite a while back, but apparently not. And obviously Fannie is seeing it as well, because again, this is being pulled from reports they have in their own pipeline. Poor neighborhood, good neighborhood, crime-ridden area, desirable neighborhood or location, undesirable neighborhood or location. Okay, so we're talking about the use of subjective terminology here. As a sweeping generalization here, but I'm going to comment on it for a minute. I would say I'm not certain that it's been every single one, but it has been predominantly, overwhelmingly, with maybe 1 or 2 exceptions. The cases that are getting turned in are an instance where, and I'm going to use residential lingo for a second, specifically UAD lingo for the federal, for the GSE lending reports. Somewhere in the dividing line between a C3 and a C4 subject is where all of this angst is occurring. And it comes down to a borrower having their expectation missed, whether they had a reasonable expectation or not. It comes down to a borrower having had their expectation missed and not being able to understand why. And in an instance where they said, hey, here's actually some additional sales we think you should consider. What about this one right over here? I know about that one. What about this one right over here? Well, the appraiser has concluded that the use of sale at 123 Main Street is inappropriate because it's in a superior neighborhood to the subject. Borrower who doesn't know about any of the appraisal processes looks at this and says, well, it just got sold. It's got the same number of bedrooms. It's got the same number of bathrooms. It's right over there. I drive by it every day. What do you mean it's in a superior neighborhood? What's different about that property? Is it me? And that's where we're seeing these issues arise, at least in my opinion. That's the confusion that's at play here, and why the subjective language, the non-objective, non-verifiable language, that's where this is coming home to cause a problem. If I can say that it's actually inappropriate because once you get across this line, you're actually in a different school district, and the subject is located in the number 117th ranked school district in the state, whereas you go across this one to where 123 Main Street is, and it's actually in the number 32 school district. And accordingly, the market shows that sales in that market area actually have an increase of X% over the sales. There is an objective way to convey sort of the differences there. But one of the problems we run into is that the subjective language is also something of a moving target. We don't have a perfect answer for what it is. In fact, you'll notice that the list as styled here by Fannie, or I'm going to flip the slide over to their update, but you'll notice the language they include continues to be including but not limited to. Okay, so I'll toggle back for a second. Prior to this, it was a crime-ridden area. Now they've touched on crime and its variants. Okay, so it's been updated, or crime rate or related data. Okay, that's one modification that Fannie themselves have made to this list, but it's not an all-encompassing list by any stretch of the imagination. So part of the concern here is for appraisers, it is a constantly moving target. More terms, more phraseology is coming onto the list and coming off the list. And in fact, the algorithm that's being utilized to identify, select, and submit these reports to the state regulators, because each one of these claims that comes up is being the subject of, and I have to be careful, Fannie will tell you, they don't submit complaints, they submit tips. And so all of these tips that are being submitted to the states are coming with, we're not telling you that they've violated any fair housing laws or any license laws. We're just making you aware that they have possibly committed a violation of one or more of these laws if you're willing to look into it and do something. Well, of course, the state's going to look at it because it got submitted into their complaint portal or on their complaint form. But it's a moving target because nobody knows exactly what each of the words is that's being utilized as a filter to identify these reports. In fact, I've had in multiple states now, I have had a case where the appraiser has been turned into their particular state board for a singular use of the word gentrification somewhere within the narrative of the report. I actually joked about this before with some of the folks as we were getting the webinar set up, but I'll mention it to all of you, probably against my better judgment. I'm still looking for the appraiser out there who will take Fannie's slide deck and the slide from Fannie Mae itself talking about the impacts of gentrification on the neighborhood and just throw that slide into the report to see if Fannie Mae's algorithm catches that use of the word and rejects the report and sends it in. I wonder if their software is actually dialed up to such a degree that it's going to weed out their own source material. I don't know. But it's a matter of curiosity to me anyway, because that's the level of things that we're dealing with here. And the reality is the states are getting inundated with these. They don't want to receive these complaints any more than you want to be on the receiving end of one of these complaints. But that's the nature of the game as it is at this point. And it's not specifically enumerated. There's not a singular list that you can go to and go, here's all the words I'm not allowed to say. It's not there. The only thing I can caution you with is you have to use your better judgment, and where you are going to make any sort of a statement of certainty, you need to use objective and verifiable data to support your position, whatever it is. Don't tell me that this is superior or inferior. Don't tell me that this is obviously desired or undesired or preferred or not. Tell me why that is. Go that one next layer, do the analysis, and use your words to protect yourself by saying, I'm not the one who's coming up with this on my own. The market participants are reacting this way to this factor, and accordingly, then it is or is not appropriate to compare this to my subject. So with that, that is essentially the end of the slide deck. I'm going to go ahead and take some questions then. In fact, we just had another one come in. Has the data for this dirty language been more detailed down to the states and areas of the state to identify specific training needs, or is it nationwide equally? That's a fantastic question, Trivia. Thank you for that. The answer to that question is, as it's being presented to the public, to the appraisers, and to everyone else, it's essentially just a national, hey, we're identifying these language concerns and we need to address them in some way, shape, or form. I have not heard yet that it has been presented to the state regulators in any more condensed version, or that it's being specifically distilled and targeted to, hey, in this region of your state, you're having a particular use of these languages terms. In this area of your state, you're having this particular issue. I'm not hearing that any of that is happening yet on any of these concerns. So on that level, I'm going to jump into, we actually had a few people also go ahead and pre-submit questions. So I'm going to touch on those as well. If anybody else who's an attendee right now has additional questions to insert, please go ahead and continue to throw those into the Q&A box, and I will try to get to them. I will say this. Okay, so here's the pre-submitted questions that I've gotten. First one that comes up, and unfortunately, I don't know who these came in from. I just have the questions, but thank you for submitting the questions, whoever you may be. I will say, should an Airbnb property be identified as such when marketing it for sale? I'm going to give you the Mel Black. It depends, again, but in terms of how that works, that's not specifically a bias or discrimination concern. I think that's more of a general best practices concern. I think the use of the property as a short-term rental has a significant impact on its marketability and ultimately on its valuation. And let me tell you, it is a whole nother webinar. Frankly, it's probably a whole nother 7-hour webinar as to how valuation professionals should consider income streams on a short-term rental and the corresponding, and who is qualified and authorized to perform those valuations. That's a whole separate topic. But I think it's critical that market participants and valuation professionals should know, is the property being utilized and marketed as a short-term rental, or is it being circulated as either owner-occupied or a longer duration rental in a market that makes adjustment for that and can account for that. So that's the question there. That, again, it's not specifically bias or discrimination related, but I think it's a general practice one, and it's a good idea to address that in the marketing and the advertising of the property so that everybody is aware of how that property is positioned. How many legal suits are currently in progress in North Carolina involving bias? I am unaware of any active lawsuit at this moment in North Carolina. There are, however, a number of HUD complaints that encompass that, and how many nationwide. There's a small handful, 4 or 5 lawsuits presently coast to coast that are still active at the moment. I actually do anticipate an influx of those. How are property valuations that have been previously affected by bias being corrected? There's really no good answer for that right now. Nobody quite knows how to separate the wheat from the chaff. And so as a result, we're not really correcting for past valuations other than trying to identify instances where bias may have occurred. And this goes to a question that actually just came in live as well, which is, have I ever encountered racial bias in an appraisal? I will tell you, from the ones that have hit my desk, no, I have not seen racial bias being a concern in an appraisal that I've taken a look at. I've seen bad appraisals. I have seen what I will call competency issues. I have seen standard 1 and standard 2 concerns, but I haven't seen it come with any sort of a racial motivation. I have seen it come with a matter of, hey, is this the sort of thing that is just done in the ordinary course? And maybe the appraiser had a bad day. Maybe the appraiser missed the mark in that way. Yes, I've seen that, but not because I've seen it where somebody has intentionally attempted to discriminate against somebody because of a particular classification. Question pre-submitted as well. How can we gain awareness of when this is occurring? Do we rely on CMAs? Can we get appraisal history? We don't have an appraisal history on that. So there really isn't one to go to. I think what you have to look for on both sides of this, if you are the appraiser or if you are the user of an appraisal report, you've got to look for whether or not the opinions and conclusions are supported by objective and verifiable data. And if they're not, it doesn't mean it's bias or discrimination, but there's a question there as to whether or not the opinion or conclusion is actually supported or supportable. And I think that's where the question comes into this. There is a need to make appraisals more reader-friendly, user-friendly. That doesn't mean that it's eliminating bias or discrimination where there is some or where there isn't some. But frankly, I think a lot of this arises out of misunderstanding and misuse. And if we can address that, then we might be able to nip some of the concerns about discrimination in the bud as well. I am effectively out of time. We had a couple of additional questions pop in. I'm going to try to get to them in like 30 seconds or less, and then I know people are going to have to get going. Can you expand on the ROV procedure and when it can be driven to a second appraisal? I don't really have that time here, but what I can tell you is the borrower-initiated ROV processes are published and available. So even if you run a search engine search for those procedures, you'll find it out there, and it'll indicate to you what steps of the process must occur and what would ultimately give rise to ordering a second appraisal and the report. Question following that, why have the regulators not received this level of information from your perspective? Having just completed a term as a regulator, NCREC is focused on fair housing issues to educate the licensees. Couple of reasons. One, I don't know that we have any hard and fast details that can be shared to the regulators yet. We're all sort of figuring it out in real time. I'm not sure anybody has had the time to do the retrospective analysis and really identify these problems yet. So I'm not sure there is a clean and clear version of that that can be given to the regulators and say, hey, go find this. I don't know that we know that answer yet. You have recommendations for realtors agents in the use of CMAs to protect themselves, similar to the guidance being provided to appraisers. I'd sort of harp on the same thing, that if you're going to use objective and verifiable market data to analyze and arrive at your conclusions, just stay in that realm of objective and verifiable. Hey, here's my range. The market has provided me with these variety of sales. It goes from A to B. I know we're somewhere within there. Based on what I'm seeing, this property falls to this end of the range or this end of the range because of ABC factor that I can see. But again, it's everything we can do to sort of eliminate the subjectivity out of that. That's just going to go a long way towards allaying concerns. And finally, the question here, and can we get a copy of the deck? Yes, absolutely. You are all going to receive a copy of this slide deck in a PDF form. So that will be coming to you. All right, so I'm going to stop the screen share there. I thank you all very much for having me today, and for participating. Questions are excellent, and I thank you very much for attending and feeding the questions, because that's great discussion. And if there's anything else I can do, please don't hesitate to ask.
Thank you, Craig. I really appreciate you taking time to be here with us today, sharing your valuable insights. I was riveted. I don't know whether I'm scared more or I feel better, but it certainly is going to lead to a lot of conversations among us appraisers with each other. So we really, really appreciate you. You were at the top of your game.
Well, I got to say, if you were riveted, I think you need to get out more, but that's for an offline conversation.
Well, that's appraisers. You know, we're stuck in our little hole, and to hear things like this, you know, unless we take a class with Mel Black or something like that, you know, we used to have to take all our classes in person, and so you'd find out these kind of things, you know, in classes. But now you just don't. You feel like you're out of the loop, and I really, really appreciate you being here.
Oh, thank you very much for having me. It's been fantastic. I appreciate you having me out, and I appreciate the opportunity. And yeah, if people have follow-up questions or whatever, obviously my contact information was there. So please, folks, don't hesitate to reach out. And thank you again. I appreciate it.
I appreciate it. All right, that concludes our session, folks. Thanks for attending.